Hello, everybody. Hello, hello. Welcome in. Hello, hello, hello. I am, this is just a kind of a pop up, everybody. I apologize. I'm unable to kind of get a regular schedule going here for my lives. We have a new filing out of the New York case. Hello, happy Monday. Happy Monday. So, everyone, we've got our sentencing coming up on the 18th, right, in the New York case. And we've had Mr. Trump request moving the date. We've had today, we have a filing now from the government's response. So it's just one page. I thought I would read that here while I can. So let me go ahead and put my sticky note together. So, New York criminal case. And this is the sentencing filings here. Hello, so welcome in. I apologize for not being able to be more consistent with my lives, but I have just not been able to do that. So welcome everyone. Again, we have our sentencing for the New York case. Everyone is set for the 18th. Now, Mr. Trump has requested a change in time. He has requested that the sentencing be moved. Hello, Murray. Good to see you. So I wanted to read through Mr. Trump's request, and then just today we have a new filing from the government in response. So, oh, thanks, Desert Skies. Yes, I know it's just unpredictable. So let's go ahead and get started. I do have a sticky note here that I'll keep on so everyone knows what we are talking about here. But the first filing that I will read through here is going to be August 14th. And this was, the first filing was done by Mr. Trump. So we'll do a Trump letter, and then we will do government response. And they're both not very long, so we can kind of chat about it once they get sorted out here. So welcome in. Hello. Yes, it's been a bit of a struggle, everybody, recently, but hopefully things will get sorted out pretty soon. So let me go ahead and get started here. Again, this is the New York criminal case, everyone here. Hello, Suze. And we've got two filings now, one from Mr. Trump and one from the government. So let me dive in here. Dear Justice Merchan, so we're starting again with Mr. Trump's filing here. The court should adjourn any sentencing in this case, though one should not be necessary because dismissal and vacator of the jury's verdicts are required based on presidential immunity until after the 2024 presidential election. We respectfully submit this pre-motion letter seeking that adjournment relief pursuant to CPL section 380.30 sub 3, which can be deemed the motion. So, all right. Notwithstanding the court's ruling on the disputed recusal issue, so Judge Merchan has already ruled on that, the requested adjournment would prospectively mitigate the asserted conflicts and appearances of impropriety, which are also the subject of an ongoing congressional inquiry, which I'm not sure. All right. In yesterday's ruling, so this was August 14th, the court did not address the significance of the 2019 conversations with Your Honor's daughter criticizing President Trump's use of Twitter, with the new fact being that existing tweets from President Trump at the time of the conversation are squarely at issue in the pending presidential immunity motion. Moreover, since the most recent recusal motion, as Kamala Harris did previously, Tim Walz wrongly referred to this case in a public speech as the Democrat Party's nominee for vice president. In the same time frame, Michael Nellis, a business partner of Your Honor's daughter at Authentic Campaigns, posted on social media about inter alia making maximum donations to the Harris campaign and using his clout with that campaign to get Walz to talk on our White Dudes for Harris call last week. Sentencing is currently scheduled to occur after the commencement of early voting in the presidential election by adjourning the sentencing until after the election, which is of paramount importance to the entire nation, including tens of millions of people who do not share the views of Authentic, its executives, and its clients. The court would reduce, even if not eliminate, issues regarding the integrity of any future proceedings. So again, everyone, I'm reading the first letter by Mr. Trump requesting moving his sentencing in the New York criminal case. The requested adjournment would prevent the DA out of New York from filing a sentencing submission while the court is still considering the presidential immunity motion. In an August 5th, 2024 letter, Your Honor indicated that the court will issue a decision on the immunity motion on September 16th of 2024, that the existing September 18th sentencing date remains unchanged, and that the parties should keep these dates in mind for purposes of sentencing submissions. However, in the July 2nd, 2024 letter, the court acknowledged that the sentencing may not be necessary in light of Trump. That's the U.S. Supreme Court case that was decided earlier. We have explained in our immunity briefing why no sentencing should occur and why the case should be dismissed. While that is a pending question before the court, the DA out of New York should not be permitted to file a public sentencing submission that will include what the Supreme Court described as threat of punishment in a manner that is personally and politically prejudicial to President Trump and his family, and harmful to the institution of the presidency as a result of the type of peculiar public opprobrium associated with the proceedings that troubled the Trump court. Again, that Supreme Court case here. The requested adjournment is also necessary to allow President Trump adequate time to assess and pursue state and federal appellate options in response to any adverse ruling. The Trump's decision arose from an interlocutory appeal, while proceedings were stayed in federal trial court. And the Supreme Court confirmed that a trial court's denial of immunity is appealable before trial. It follows that any denial of the pending motion is immediately appealable in a similar proceeding posture. Put simply, until the DA out of New York's presidential immunity violations are addressed fully and finally, this court may not adjudicate the matter, including at sentencing. A single business day is an unreasonably short period of time for President Trump to seek to vindicate these rights, if he must, in order to avoid the prospect of an executive branch that cannibalizes itself in future generations. Right, so that's a lot of words. The current schedule contemplates the type of highly expedited proceedings that the Supreme Court already criticized, but the DA out of New York has demanded, as relevant here after wrongly denying that presidential immunity existed for months. DANY purported to authoritatively address the scope of presidential power and the immunity doctrine inaccurately in a brief filed just 23 days after the Trump decision. They did so despite only limited federal litigation experience, with the notable and telling exception of a former high-ranking official from the Biden administration, and without any input from the federal government that they felt worth mentioning. The court still has not addressed our request to respond to the purported amicus brief, despite the fact that the court has had an opportunity to consider the arguments in that filing since July 29th of 2024. In contrast to all of this, on August 8th of 2024, the special counsel's office notified the federal judge in the District of Columbia that they were continuing to assess the Trump case, including through consultation with other DOJ components, and had not even finalized a position on the most appropriate schedule for the parties to brief issues relating to presidential immunity. In that case, the schedule for litigating presidential immunity will not even be determined until at least September 5th of 2024 status conference. That timing illustrates just how unreasonable it is to have the potential for only a single day between a decision on first impression presidential immunity issues and an unprecedented and unwarranted sentencing. So he's upset that the immunity timing is set for right before the sentencing. Finally, setting aside naked election interference objectives, the There's no valid countervailing reason for the court to keep the current sentencing date on the calendar. There is no basis for continuing to rush. Accordingly, we respectfully request that any sentencing, if one is needed, be adjourned until after the presidential election. So again, this is just a letter Mr. Trump has written regarding his New York sentencing being moved. Okay, everyone? So this was submitted here by his attorney. So that takes everybody up to speed to where we are today with a new filing that came out from the government. So let me grab that real quick. Here we go. So this was just filed, although it is dated August 16th, it was just filed here. Bamboozled. I agree, Murray, I agree. All right, everyone. So we've just done the Trump letter. We will now do the government's response to Mr. Trump's letter. He was not even president at the time. Correct. So it's a lot. There's a lot of interesting things going on. Oh, the teddy bear. Thank you so much, everybody. Yes, and just as a friendly reminder, Judge Merchan's order that came out here did reaffirm that the sentencing was to be held, and this was filed dated August 13th. And again, he was saying, look, we're going ahead with the sentencing. So now we will see what the DA's office has to say about it. Dear Justice Merchan, again, this is from the DA's office in New York. This letter addresses defendant's August 14th, 2024 letter requesting an adjournment of the sentencing date. The people defer to the court on the appropriate post-trial schedule that allows for adequate time to adjudicate defendant's CPL Section 330.30 motion while also pronouncing sentencing with unreasonable delay. This section of the code, again, is cited. To assist the court, we note the following points. So here is the government's response again. So here we go. I'm going to just move this over here. Hopefully everyone can again see what we're talking about. Defendant's letter indicates for the first time his intent to seek interlocutory state or federal appellate review before he is sentenced of any adverse ruling on his CPL 330.30 motion. It is correct that the denial of immunity from prosecution is immediately appealable, but here, in contrast to the defendant's criminal case in D.C., the question of defendant's immunity from prosecution is not presented. The only question now before the court is whether a small subset of the trial evidence was improperly admitted in light of brand new evidentiary rule that derives from official acts immunity, and if so, whether any error in admitting official acts evidence was harmless, which in my humble opinion is exactly what it would be harmless. So here's footnote number 1. As the people noted in our opposition to the defendant's pending immunity motion, the evidence that he claims is affected by the Supreme Court's ruling constitutes only a sliver of the mountains of testimony and documentary proof that the jury considered in finding him guilty of all 34 felony charges beyond a reasonable doubt. The Supreme Court's recent decision did not consider whether the trial court's ruling on that distinct evidentiary question is immediately appealable, and there are strong reasons why it should not be. Nonetheless, given the defense's newly stated position, we defer to the court on whether an adjournment is warranted to allow for orderly appellate litigation of that question or to reduce the risk of a disruptive stay from an appellate court pending consideration of that question. Then we have footnote number 2 here. Assuming that defendant seeks an interim stay of the sentencing hearing immediately after this court's September 16th ruling, the people respectfully note that an appellate court considering such a request will understand that without an interim stay, it would have to receive briefing and decide certain issues of first impression in one day. So he's saying, I think they know. The people are prepared to appear for sentencing on any future date the court sets. The people are also mindful that significant public safety and logistical steps by multiple agencies are necessary to prepare for court appearances in this matter. The defendant's newly, making sure I'm in frame, stated position concerns an immediate appeal of the court's CPL 330.30 ruling may mean that significant preparatory steps are taken, only to have such steps disturbed by appellate litigation. None of the defendant's remaining arguments merit any consideration. That's funny. So he's saying we don't need to get into anything else. First, although couched as a scheduling request, defendant re-raises for the fourth time a recusal grievance based on a false claim of potential conflict that have already been rejected over and over by this court. The First Department and the Advisory Committee. Defendant's ostensibly new argument about the court's family members' co-workers' tweets is bizarre and has nothing to do with the post-trial schedule. Defendant's concern about a public sentencing submission from the people is also misplaced. Any pre-sentence memorandum the people submit would be sealed. The only way the memorandum would become public is if the court orders otherwise or the defendant unlawfully discloses it. Finally, defendant's apparent insinuation that the state's prosecutors are incapable of applying federal constitutional law is fundamentally flawed, given that the people and this court protect and apply federal constitutional rights every day. Based on the foregoing, the people respectfully defer to the court on the appropriate post-trial schedule. And then it's respectfully signed here out of New York. Oh my gosh, everybody. We are fighting. The girls are fighting. Oh my gosh. Although there's really not much here to fight about, really. It's... I think the DA's office is just saying, oh my gosh, when are we ever going to get this finished? Ever. Yes, so I think the DA did okay here. Oh, love the blue. Thanks, Chris. I appreciate that. Yes, this is one of my favorite colors as well. Yeah, we definitely... he has requested multiple times, everyone, for the sentencing to be halted. And again, if you look at Mr. Trump's very first sentence here, the court should adjourn any sentencing in this case, though one should not be necessary because dismissal and vacator of jury's verdicts are required based on presidential immunity until after the 2024 presidential election. So that sentence doesn't even make sense because if he's saying there's a vacator, he's saying only vacate it until after the election, not vacate it in total. I mean, that sentence doesn't even make sense. So he's got a lot of things that they're working on here for sure. Ping pong match, quite a bit like that. Not very demure or mindful. I think that's accurate. I think that's an accurate depiction for sure. But again, I think that was, the DA here in New York is walking a fine line between saying, wow, we are insulted, and on the other hand, just saying, not kind of going down that huge negative road. So, it was insulting to say that they don't know how to apply constitutional law and that the courts won't have any ability to do their jobs. Yes, but I think they handled it pretty well. The judge didn't keep kicking the can. I agree. And he is the one that has said, everyone, this is Judge Merchan's order again that came out, most recent order here. And he has said, look, we are set for sentencing and you need to be ready for that. So he's been pretty clear about that. So we're ready to go. And I don't see how anything in Mr. Trump's letter would rise to the level of making it so that the sentencing couldn't occur. He did do one continuance, but other than that, I don't see how he would do another one at this point. Yeah, the judge is tired. I think everyone's tired. It's like, let's get it done so you can appeal that, come on. Can they bring in Taylor Swift to read the sentencing? I'm not sure. I'm not sure here. Let's get this finished up. I agree. We need justice. I agree. So when they couldn't find a crime and the judge says, if you feel he's guilty, then he's guilty. Well, he was convicted by a jury of his peers, so crimes were found. We're all tired. Oh, I know. It still seems far away. I know, everyone, I know, but it's really not. It's really not. If we take a look again, I've got my calendars back out, up and running, because we have so much now starting to go on. The sentencing is only a couple weeks away. We're really only a couple weeks out. We did get our answer, though, on whether or not we would find any pre-sentencing information, and it looks like it's going to be sealed. So that's what the DA was putting in their letter out of New York, that the only way that information would be made public is if Mr. Trump made it public, because it's going to be sealed. So it looks like we're not going to be seeing any of that pre-sentencing information. But again, we are just a few weeks out here of sentencing. Right. Sealed why? I think most of this case, actually, Jan, great question. Most of this case has been sealed up just because of, in the interest of not getting out of control. I think some of the privacy issues that are going on in this case, they've sealed quite a bit of it. So that's why it's kind of hard to get information out. In fact, whenever there's a filing, which I check pretty much every day, multiple places to see if there's a filing. But if there is a filing, it's like, oh, yay, we get a filing. It's like a treat because most of this case is sealed up so tightly here. How do we get it unsealed? It's just going to take some time. I think until the case is finished. Once it's finished and a little more time goes by, and it's all in the interest of safety and due process. So they've already come to the decision to seal most of it. So we don't really have the full story because it's sealed. Because half the story is sealed, so we're not sure. Trump donors and supporters are tired and weary. Well, yeah, I mean, everyone, I've been posting about the Trump cases, and I tell you what, I mean, there are just hundreds of cases going on. I just posted on the Electric Avenue case that's going on. There's that. But there's just so many cases, so many, and it's exhausting for everybody involved, I think. Likely sentence, great question. I really don't know. I really don't know at this point. It's a white collar crime situation. It's always possible. Prison's definitely on the table because we've got 34 counts here. We've got some contempt issues as well, lack of remorse. But on the other side, when we weigh it out, which is what the judges do, he's got to kind of weigh it out. We have no prior criminal convictions, no prior actions like that. We also don't have something that is of a forcible felony level. Even though this is a pretty significant election situation, we're not looking at something like a robbery or arson with this level of white collar crime. And also, it's not like investors lost a whole bunch of money as well. So, they're going to kind of need to weigh those out and figure out what's the best sentence in this situation. So I would say it's on the table, but is it guaranteed? No, I wouldn't say that it's definitely guaranteed. Well, Miss Donna, the reason I say it's election interference is because with 34 counts, it's false business records created in order to cover a situation up in order to not negatively affect the election. So that's where the election interference element comes in. Can his other cases enhance it? No, because in order for an enhancement to work, you've got to get a full conviction. So this conviction in New York could enhance his future New York convictions, but it's not going to really enhance anything else. So at this point, we don't really have that in play because, again, we've got 2 state cases with New York and Georgia, and then one and a half federal cases going. Did Cohen have prior convictions? I don't believe he did, actually. I'm glad you asked. I don't believe he did have a prior conviction, come to think of it. But he had several other charges besides just the documents issue going on here. Cohen had some tax issues going on as well. So his was a little bit different, along with Weisselberg. So they had a few other things at play. Mr. Trump only has, and I don't mean to, lower how important this is, but he has false information on business documents in order to, commit an offense. And so, he doesn't have the tangle with the taxes that they had in the other situations. In lieu of prison, can the judge require Trump to read a statement on a video that he admits to his guilt? Well, he could. I mean, judges have had that happen where they have required that as part of their sentencing, but I don't think Judge Merchan will do that here. I think Judge Merchan's going to tread very lightly in this situation, but fair. I think he absolutely will be a fair judge with whatever sentence comes down the road. But I'm not sure that an apology is something that he would require because we're in the middle of an election situation. Not sure the sentence will barely be anything. Well, again, it's accountability, right? We're looking for accountability, and that's what the judge is looking for. And that accountability is going to look very different to everybody. Some people may think only prison's enough. Some people may think probation is more than enough. Some people may think, this is all, I don't know, kangaroos eating bananas. I mean, everyone's going to have a different take, but ultimately it's up to the judge. So, and with his experience, he'll be able to figure out what's best. What about the gag order violations? Right, that will definitely be considered as part of the sentencing. I think absolutely, Judge Merchan. And if you go through and listen to any of the things with Judge Merchan during the contempt situation during the trial, he was pretty upset about that stuff. So I think that will definitely be a factor to take into consideration. Even as Martha Stewart, yeah. Hello, Denise. Yes, here I am. I'm back. What do you think it should be? Oh, that's a good question. At this point, I think my personal opinion in this kind of a situation, because Mr. Trump is unique, I think the accountability, I think the worst thing you could do, a harshest sentence for Mr. Trump would be extended probation. I think anything where he is having to constantly get permission to do anything on the daily, where he can't go and do whatever he wants without getting permission, I think would probably be the most significant violation for him. Those limitations on his freedom, I don't think necessarily need to be within the four walls of a prison. I think those limitations due to probation would be plenty for Mr. Trump. That's my personal opinion. I know, and also because I don't always feel that prison's the best option. I'm not a huge fan of prison being the only option. I think there are a lot of ways for people to be held accountable and situations where people are punished that don't involve prison. But that's my personal take, and just from working in the system so long and seeing prison. Sentencing date is the 18th. Yes. Yeah. Sentencing of incarceration would diminish the severity of the offense. Yeah. And again, it's hard. I really just don't know. I think anything, again, where his ability to, his freedom of movement is restricted, which it will be, what he's allowed to do, he will, again, have to get permission for everything if he is on probation, is limited. But again, I think that there are a lot of alternatives to prison that are much more appropriate for accountability in a lot of cases, not just Mr. Trump. That's my overall feeling in the justice system, is that I'm not sure prison is always appropriate, even in situations when it's mandatory. I'm not sure it's always appropriate. So that's just kind of my personal take on that. Leaving the financial executor, whatever he's called it. Mr. VC, if he gets probation and violates, could you see jail time? Of course, Kaya. Yeah, if he violates, then he's out, right? I think absolutely he'd be out. Could a fine be ordered? Absolutely, Vincent, definitely. That could be part of it. Access to the internet, that could be part of it. Financial for 20 years would be a good sentence. Oh my gosh. Oh, yes. Anything on his finances is going to be a pretty big hit for sure. Yeah, they will have to get his DNA. They'll have to do that. And they'll also, any kind of testing, UAs or hair stats, whatever, that kind of testing. And they can do that at any time, for sure. So they could just walk in his door at any time if he's on probation. They don't need to knock. They can just say, hey, we're coming in. They probably will because he's got Secret Service, but be like, hey, dude, we need you to do a UA right now. And he'd have to do it. Like, he'd have to do it. I mean, that's some pretty significant stuff. Like, hey, you're running to be president of the United States, but I'm going to need a urine analysis. So, I mean, that's a lot. It's a lot. Yeah. So I think it's important to have accountability. I think we have 34 counts of Class E felony situation, and that accountability, I think, needs to be held up. So will he get jail time or probation? I really just don't know. Definitely violate probation, then let it slide repeatedly. Perhaps, or not. I think the eyes of the world are on him. I think everyone's watching so carefully here. What will make him stop his games? Well, Alice, great question. I would say the only thing that stopped his games in the Carroll case was, millions of dollars. So I think that's pretty much it. So if he is fined repeatedly over and over and over again, like let's say he doesn't do a UA and they're like, okay, put him in jail. And instead the judge is like, no, it's going to cost you $10 million. So, and then they go the next day and they're like, you need to do a UA. And he's like, no, he's like, that's another 10 million. So, I mean, how many millions of dollars is it going to cost Mr. Trump in order to drop a UA? I mean, that's, I think you got to figure out what works for him, what his currency is, which is what we do with all of our defendants. All of our defendants are treated that way. Everyone has a little bit different currency, what makes them do what they need to do to follow directions. Yes, Meme, I agree. His pride in extended probation, exactly. A UA is a urine analysis. That means you need to give a urine sample. And sorry, drop a UA. I apologize, everybody. Like everybody does. Support with the justice system and law enforcement. I don't think so. I don't think he necessarily has a lot of support. I think it's just everyone he's like a ticking BOMB is the problem, and everyone is handling it like a ticking BOMB. And so I don't think it means that he necessarily has friends in that kind of situation. Rather, he is being handled very carefully because he could explode at any moment. So I think that there's a little bit of a difference between those two situations, because at some point that timer on that BOMB is going to stop ticking, and once that happens, all bets are off, and it's just going to be like a vacuum of everything all at once. And I think that will happen. That will happen at one point. Will he have to turn up his passport? I'm not sure. I think he may have already. Has he put up the money he was fined yet? Yes, I think he has already paid that, although I'm getting it confused because he's had to pay multiple fines. So I remember seeing a check, but that actually, I think the check was in Engeron's case. So he's paid some fines. I'm not sure if he's paid all fines. Again, it does get confusing. He's got a lot. Yikes. This reality shows prison break. Oh my goodness gracious. I'm not sure about that yet. Is there a maximum sentence that he can be given? So the maximum sentence would be, if it's 4 years a pop, so 4 times 34, and if it ran consecutively, that would be the maximum sentence. So if you crunched out those numbers, which I will not do because I don't want to embarrass myself, but that would be the absolute maximum sentence, would be 4 years per count to run consecutively one after the other in that situation. There's so many to get mixed up. Oh, I know. I'm struggling. And even now, everyone, I'm looking at, the Cohen case against Mr. Trump, where Cohen's actually appealed all the way. He's got a cert on file to the Supreme Court. So we're talking like millions of dollars all over between all of these lawsuits, everyone. It's hard to keep it all straight. 136 years. Okay. Yeah, there you go. Yes. So he's paid the bail, but he was also fined in the Engeron case. in the civil case in Ingrant for violating the gag order. So he was fined in that case. So that's the fines that I remember seeing the check on file for. Will the last one end life in prison? Because now I'm not sure. I'm not sure his cases will ever be done. I think his cases will outlive him. In all honesty, everyone, I think they will continue on past after he has gone. And even if he lives his maximum life amount. Now, don't get me wrong. I mean, if he lives to be the average age of a man in the United States, if nothing happens to him, his health is great, and he lives as long as he's supposed to live, these cases will still go on because there are so many of them. I mean, again, the Grant case, which was filed in 2020, is just now getting into a motion for summary judgment. I mean, 4 years later. So these cases are just going to last a really, really long time. So, right. I mean, I'm not saying his life's going to be shortened by any means. I'm saying no matter what, these are going to go past him. Yeah. How would his cases work? Who would be responsible? Great question. So if he has cases, his criminal cases, you don't have to worry about if he were to pass on. But in the civil cases, then it's your estate, right? Then your estate is the one that has to pay if you're found to be liable, and you can continue to go after someone's estate even after they've passed. So his estate would be tangled up in litigation forever, for a very long time, until there's nothing left. Nothing left. Oh, sorry about my Post-it note. I just wrote it with a pen instead of a Sharpie. I apologize. Well, I don't know if we're ever truly going to know the whole truth for all of this, but is Trump a defendant in the Arizona case? No, Vincent. No, he's not named as one of the defendants in Arizona. And I think that was a strategic move in order to kind of keep all of the, craziness out of it, so they could actually go forward with the case. They are really determined to hold the locals involved in that situation accountable, along with the top players. And rather than pull Mr. Trump in and make it into, this huge, big, show, I think they really wanted to focus on that level of accountability. So he has not been named as a defendant. He could be. Oh my gosh, I don't know about that. Oh my gosh. Brini, that's dark. That's dark. No, I don't know anything about that. Oh my gosh. This is a white collar crime, everybody. This is a white collar crime. All right, it's crime. So, don't do crime, but this is a white collar crime. We're not necessarily, oh my gosh. All right. All right. Let's let's remember that. All right. I know we're frustrated, but right. No, he'll never be President Trump to me because he's a defendant, and defendants are always a mister. That's just how that goes. Well, the thing is about DA Bragg is that he kept pursuing it. So there's something to be said about that. There's something to be said about a prosecutor that keeps going forward, no matter how much grief they're getting. So I think it's okay to laugh. I think it's absolutely okay to laugh, everyone. I think if we stop laughing, we are going to be in trouble. So we were really frustrated. Well, understandably so. Absolutely. Yeah, I think Bragg has made some mistakes. I think he could have done things better, but hindsight's always 2020. I think he did the best he could with what he's got. Is there a book of white collar crime we could do with a little to no punishment? No, I think our white collar crime, you just look to see what the sentencing options are. And our sentencing options for white collar crime tend to be much less than if you are, in a forcible felony situation. So you just would compare punishments and you can see how we treat our white collar crime. Yeah. I don't I think it's okay to chuckle when we can, everyone. I think we have to do that. We've got to keep a sense of humor, and if you talk to any prosecutor or defense counsel, that's the only thing that's going to keep you sane. You just got to. Mhm. Mhm. He's buying his way out. Well, I think everybody, if you've got the money to do it, that's kind of what happens. I think Melania divorced him. Would her settlement be granted with the cases pending? Yeah, I think that's a good question. Family law cases and divorce cases, they're just on a different road. So I don't think they would be involved in any of this other than to try to figure out how much of his assets. But she's kind of already got she's already gotten predetermined what she's probably going to get when if she divorces. So I don't think it will be affected. It's just a matter of will he actually have the assets that she is owed at the time. I think will really be the only question. uh oh my gosh, oh I know, oh yeah, people, you gotta leave Taylor Swift alone. Like, don't kick that hornet's nest. Like, what are you doing? Don't be messing with that. I don't. Oh my gosh. So the IRS is continuing to go after him, but I think the IRS, much like a lot of our processes, it's a slow moving machine, but a crushing machine nevertheless. Much like a tank, it's going to cause a lot of damage, but it's going to cause it very slowly. So I think that's definitely still going. Well, the cause a lot of damage, but it's going to cause it very slowly. So I think that's definitely still going. Will the Lucia, are you back? Do I need to start singing and embarrassing myself? And then I'll come back. Okay. Okay. Sorry. We're back. It's okay. I was just, I knew I lost you, so I didn't say anything new. Sorry about that, everybody. Sorry about that. Whoo, I lost you there for a minute. Yikes. No. No. Oh, sorry about that. Yes, we're back. I apologize. I don't know what happened here. Oh, my goodness gracious. I thought it was me. No, it's not you. No, it was everybody. All of a sudden it just paused and I was like, what? What just happened? I didn't think I was being too controversial. Did he get sentenced? No, he's set for the 18th to be sentenced. So we should see something before then. Actually, we should have a whole bunch of things going on right around then. It's going to be pretty busy. So that's funny. Oh my goodness gracious. UK will welcome in. Welcome. Yep, you bet. But I will tell you what, everybody, with that, I will go ahead and sign off for this kind of lunch and learn. But I've got, again, just to remind everybody, we had our new letter that was received here out of New York regarding the sentencing moving, and the DA is just saying we'll defer to the court, whatever the court wants to do. So that's where they're set up. We will see. The last order that Mershon has done has said clearly we are going to do sentencing on the 18th. And so there we go. Oh, yes. Now, as far as my next live, everyone, I apologize, but I'm not sure exactly when it's going to be. It really just has to, all the stars need to align in order for me to be able to kind of make it happen. So I will try to be on again as much as I can, but turn your notifications on for sure, everyone, because I'm kind of out of my normal schedule at the moment. So I will be back on. I have orders I need to read from Judge Engeron. I want to do the original order for that one. I've got Trump v. Clinton that I'll be reading. So I've got lots of things that I do want to read. It's just a matter of being able to come on and do a full live for everybody. So I'm kind of being a little bit extra protective of my health right now, but keep an eye out for me, everyone, and I will be back as soon as possible. With that, I'll sign off for today. Thanks for coming and hanging out, everyone. I will catch you all later.